Welcome to Pop Your Biz. I'm Amanda Butler Schley, your go-to business lawyer and purveyor of all things pop culture. Join me as I break down today's hottest legal headlines into bite-sized pieces. We use the lawsuits of your favorite celebrities and worldwide brands to teach you how to keep your business on the right side of the law. Let's dive in. We're back with another episode on Lizzo's labor and employment lawsuit, brought by three of her former backup dancers. We spent the first episode going line by line through the dancers' complaints and allegations, and then our last episode really dug into the defenses offered by Lizzo, her management team, and Shirlene Quigley, her very religious dance team captain. Reading all of the documents from start to finish was no small feat, but to get beyond the headlines, you actually have to do the digging and get into the nitty-gritty. For those of you who didn't watch episodes 1 or episode 2, you might want to check those out before you watch this one. This episode is entirely focused on what the judge has to say after reading and his review of the petition and also the motion to strike that was offered by the defense. So a brief recap. The plaintiffs have alleged that Lizzo and her team committed a number of labor and employment violations, including creating a hostile work environment, engaging in both religious, racial, and disability discrimination, and failing to prevent that discrimination. It also included claims of assault and finally of false imprisonment. There was a contract claim as well for a tort relating to prospective interference with a third-party contract. Lizzo and the other defendants asserted only a single defense, and that is known as an anti-SLAPP defense. What is an anti-SLAPP defense? In essence, it seeks to protect anybody's free speech rights. And so to the extent any of the allegations relate to Lizzo's involvement or the plaintiff's involvement in a performance or any sort of other exercise of their free speech rights, the defense argued that that activity is protected activity and that there's a higher level of scrutiny that the judge will have to use in determining whether that claim can move forward. Specifically, the judge is going to see whether or not that claim is more likely than not to succeed at trial. That's a lot higher standard than the standard that you initially have to prove in your petition. And so while it is a good defense, it's the only defense offered, and we're going to look and see what the judge has to say about that. I've linked the judge's order in the notes below, and I'm pulling it up on the screen right now, so let's dig in. Okay. So I've pulled up the judge's order. We're going to dive into it, see what he has to say. It looks like the order came back January 31st. So right at the end of January, he comes back after reviewing the plaintiff's petition and all of the salacious allegations that we saw there. And then he's looked at the defense's motion to strike, which is based, again, upon an anti-SLAPP defense, saying that none of these allegations can stand because the plaintiff has the burden to show that they're more likely than not to succeed, and what they have claimed is just not enough. And now it's time for the judge to weigh in. So let's see what he has to say. What's interesting when reading the judge's orders on these very first motions when they first weigh in is that oftentimes you get a very strong sense of their position on the claims. And, judges are supposed to call balls and strikes. They're not really supposed to be involved in litigation, but they subtly give you some good hints on where their head is at and what they think has merit and what they think doesn't have merit. And so the very first place that you get that is always going to be when the judge describes the background. And in describing what they say as the facts, what the facts are, and which facts they choose to state and which they omit is somewhat telling. So when we're reading this, I want you to think about what was alleged by the plaintiffs and then also what was alleged in the defense's motion to strike. And let's see what ends up staying or what ends up being highlighted here when the judge retells it in his own way. So starting with the background section, he says that the plaintiffs Ariana Davis, Crystal Williams, and Noel Rodriguez filed this employment discrimination action against defendants Big Girl, Big Touring Inc., Melissa Jefferson, and Shirlene Quigley. And according to the operative complaint, plaintiffs are professional dancers who worked with Lizzo. Plaintiffs allege that in March of 2021, Davis and Williams first met Lizzo while they were on her reality television show called Watch Out for the Big Girls. The show centered on contestants competing for the opportunity to join Lizzo as dancers on her tour and live performances. Plaintiffs contend that Rodriguez was hired in or around May 21st or May 2021 by Lizzo and BGBT for a music video and later as part of a performance group that supported Lizzo during live shows. While Rodriguez was working on a music video for Lizzo, she claims she was approached with another job opportunity that would have required her to work during the same period as rehearsals for Lizzo's show. Plaintiff claims that Rodriguez spoke with Lizzo's tour manager, Carolina Gigliotta, about taking this opportunity, to which Gigliotta stated, "Do you want the job or not?" implying that Rodriguez should not take any other jobs while hired as a tour dancer. Plaintiffs Davis and Williams contend that they were first introduced to defendant Quigley in or around August 2021, which is when filming for Watch Out for the Big Girls began. Quigley was allegedly vocal about her religious beliefs and purported proselytizing whenever the opportunity arose. Plaintiffs assert that Quigley was particularly interested in Davis and preached at her about their shared Christian identity. After finding out about Davis's virginity while filming, Quigley purportedly made a point of bringing that up in the following months and sharing it in interviews and on social media without Davis's permission. Plaintiffs allege that one of the requirements for Watch Out for the Big Girls was a nude photo shoot that made some contestants uncomfortable, including Davis. Davis claims she did not want to be photographed nude, but felt she would be sent home if she refused or did not perform well. Davis claims that she broke down in tears from the stress and was eventually allowed to participate partially clothed. Plaintiffs assert that both Williams and Davis were chosen to be part of the dance team accompanying Lizzo on her tour. Plaintiffs performed with Lizzo from September 2021 to April of 2022. Okay, now, quick tip. Do not ever pass up these footnotes. Footnotes are where judges really speak. So looking at this footnote, it looks like the judge footnoted this up here. The court typically does not cite from the complaint on a special motion to strike. However, the parties' and witnesses' recollections of events vary so widely that it is best to focus on the allegations to provide context for the lawsuit. This is not meant to imply that the court takes the allegations as true. That said, the various declarations plaintiffs submitted in support of their opposition papers are consistent with the allegations cited herein, although declarations defendants submitted in support of their motion are not consistent with the more troubling allegations. Wow. Because in the special motion to strike context, the court, for prong 2 discussed below, must take evidence in opposition to the motion as true and draw all reasonable inferences in the opposing party's favor. The court recites from the complaint and the plaintiff's declarations here. Defendants deny many of the allegations, and the court is, of course, making no factual findings as to any of it. Well, there you have it, right? The judge is basically telling us in these footnotes that he read all of the declarations, he read the complaint, he read the defense's motion to strike, and he's saying that the declarations submitted by the plaintiffs more likely support the allegations of the plaintiffs than the defense's affidavits that the defense submitted. Specifically, let's just read this one more time. Various declarations plaintiffs submitted in support of their opposition papers are consistent with the allegations cited herein, although the defendant's declarations submitted in support of their motion are not consistent with the more troubling allegations. Interesting. So we had dropped all of those declarations in the last show's notes, and we have not gone through those line by line. I read some of the more interesting ones to see, what I had to say or what they had to say. And again, I discounted a lot of the employees' declarations as they felt obliged to supply them. So, I didn't put a lot of weight in them. And the judge is essentially conferring or affirming that his take on that was that more of the affidavits support the plaintiff's position than the defendant's position. So he's using a lot of the plaintiff's facts here because as part of his evaluation in determining whether or not they have a likelihood of succeeding, he has to take any of those allegations as true. And that is what he's saying in this footnote. So he is using the plaintiff's facts here to make a determination about, whether or not the allegations have a likelihood of success or not. In April 2022, plaintiffs began preparing for Lizzo's The Special Tour and worked closely with Quigley, the captain of the dance team. Plaintiffs state that Quigley continued to proselytize to everyone around her regarding Christianity and sexuality. She purportedly derided those who engaged in premarital sex, spoke about her masturbation habits, spoke about her sexual fantasies, and would simulate oral sex on a banana, which made the plaintiffs uncomfortable. Plaintiffs contend that Quigley continued to minister them by keeping tabs on Davis's virginity, preaching at Rodriguez for being a non-believer, interrogating Davis about her religious beliefs, and becoming upset if Davis disagreed. Quigley was allegedly not the only one, however, as others in supervisory roles at BGBT who allegedly had prayer circles prior to rehearsals and performances. Plaintiffs state that while the prayer circle was not an official requirement, it soon became clear to them that failure to participate was looked down upon. Rodriguez purportedly did not want to lead the prayer, but was pressured to do so. Plaintiffs claim that the complaints regarding Quigley's proselytizing and instances of sexual harassment by bus drivers went unaddressed by management, although management claims to the contrary, especially as to the bus driver. After the domestic portion of the tour came to an end in November of 2022, plaintiffs began to look for work to fill the time until the European leg of the tour was to begin in February of 2023. Because BGBT preferred that plaintiffs took on no additional jobs, it instructed plaintiffs' agents to place plaintiffs on, quote, a soft hold, meaning that plaintiffs would not be paid during this gap period, but could also not take on other work. Plaintiffs assert that due to the, quote, soft hold, they became financially dependent on the income from the tour. Plaintiffs learned, however, that other members of the tour were on a retainer, meaning that they were paid a portion of their tour rate during breaks in exchange for not taking other jobs. The dance team then began discussing how to negotiate for a retainer. Plaintiffs contend they performed with Lizzo at her Amsterdam show in February of 2023, and after the show, Lizzo invited the dancers out with her at night. The plaintiffs concede that attendance was not mandatory, but they assert that those who did not attend those events, or those who did attend those events, were favored by Lizzo. They were selected to perform with her more regularly and enjoyed better job security. Plaintiffs contend that Davis and Rodriguez were rushed into accepting Lizzo's invitation without knowing that the club was the Banana Bar, where patrons interacted with nude performers. Davis and Rodriguez claim that they tried to withdraw after learning about the club, but were unable to do so. They assert that things got out of hand when they reached the club. Specifically, Lizzo and others allegedly pressured Davis into touching the naked breasts of one of the performers, despite Davis expressing her discomfort both verbally and physically. Later, when the tour was in Paris, Lizzo invited the dancers out to the Crazy Horse without explaining that this was also a nude cabaret. Plaintiffs state that around March 9th, 2023, the dance team submitted a request for a retainer of 50% of their weekly tour rate during the soft hold periods to BGBT and to Lizzo, a number consistent with what some of the others were getting. On March 16th, the dance team received an email from Ashley Joshi, a BGBT accountant, who offered a retainer. In the email, Joshi scolded the dancers for their, quote, unacceptable and disrespectful behavior on the tour, but did not provide any specifics about what behavior triggered this comment and informed the dance team that such behavior was grounds for termination. Plaintiff points out that the dance team is comprised of full-figured women of color, and plaintiffs assert that they only were spoken to in this way, meaning that the other groups were allegedly treated differently. While BGBT did eventually agree to a larger retainer, management allegedly treated the Black members of the dance team differently than others, calling the Black dancers lazy and unprofessional, stereotypical tropes purportedly aimed at deriding plaintiffs based on their race. On April 20th, 2023, the dance team had an 8-hour rehearsal scheduled. At the end of the rehearsal, Lizzo appeared. Lizzo purportedly stated that the dancers were not up to par and accused them of drinking before shows. Plaintiffs contend that Lizzo made them re-audition for their spots, and the 8-hour rehearsal extended to a grueling 12 hours. Plaintiffs assert that the re-audition process was brutal. Davis allegedly had to use the restroom, but she felt like she might get fired if she left the stage at any point during the audition. Plaintiffs state Davis eventually lost control of her bladder, but still feeling termination, danced in soiled clothes until she could run off to change during a brief break. On April 21st, Lizzo called another meeting with the dance team to reiterate that none of their jobs were safe and reiterated that drinking before shows was prohibited. Plaintiffs assert that Williams spoke up and said that the dancers did not drink before the shows, which resulted in tension between Lizzo, management, and Williams, with the rejoinder that the declining quality of the performance was the reason for the accusation. That same day, Davis was called into a meeting with Lizzo and the choreographer, Tanisha Scott, during which they questioned whether she was struggling with something because she seemed less committed to her position. Davis claims that the two pressured her for an explanation about her personality changes. However, these comments were purportedly really focused on Davis's weight gain, given Lizzo's statement after a music festival on that specific point. Davis disclosed that she had anxiety and depression and had been diagnosed with an eating disorder. Davis reiterated her commitment to the tour, but Lizzo and Scott allegedly dismissively offered her time off for therapy. Plaintiffs assert that Davis felt that if she accepted the offer, that they would see her as too weak for the tour, and so Davis declined because she felt it was the only way to really keep her job. It should be noted that the defendants contend that there was no hidden motive and that they were truly trying to be supportive and to accommodate Davis. Williams was terminated around April 26, 2023, in the hotel lobby by Gigliotta under the guise of budget cuts. Rodriguez later questioned Gigliotta on her decision to terminate Williams in a public place. On April 27th, the dancers were called into a meeting with Lizzo purportedly to discuss notes on their dancing. However, according to the plaintiffs, once in the room, Lizzo addressed Williams' firing and demanded to know who questioned her decision to fire Williams. Plaintiffs state that Lizzo said she preferred that the dance team did not socialize with Williams before she left. Lizzo also allegedly added that weight gain was a cause of termination and supposedly looked at Davis. Plaintiffs claim that Davis suffers from an eye condition that causes her to sometimes become disoriented in stressful situations, and so in such situations, she has a habit of making recordings so that she can review them later. Davis claims that she recorded this particular meeting due to its stressful nature. According to Davis, the recording was done in order to mitigate any issues that might be caused by her disability. Plaintiffs contend that the dancers were called into an emergency wardrobe fitting on May 3rd. So this is May 3rd, shortly after this prior April 27th meeting. Plaintiffs contend that the dancers were called into an emergency wardrobe fitting. They were made to hand in their phones when they arrived. Plaintiffs assert that Lizzo then entered and furiously stated that she knew that somebody had recorded the prior meeting. She purportedly threatened to go person by person to learn who made the recording, but before she actually did so, Davis admitted that she had done it. Davis explained that she wanted to have a copy of the notes Lizzo had given them and that she had already deleted the recording. Plaintiffs state Davis was fired on the spot. According to the defendants, Davis admitted not only to recording the prior meeting, but sending the recording to Williams, which was a violation of Davis's contract, and that is why Davis was fired. As Lizzo was leaving, Rodriguez claims to have stopped her and stated she did not appreciate how Lizzo handled the situation and resigned on the spot. Plaintiffs assert that Lizzo then aggressively approached Rodriguez, cracking her knuckles, balling her fist, and stating, "You're lucky. You're so fucking lucky." Rodriguez contends she feared that Lizzo was going to hit her and would have done just that had the other dancers not intervened. Plaintiffs state that the other dancers escorted Rodriguez back to her room due to their fear that Lizzo might return. Plaintiffs contend that Davis was forced to stay behind in a meeting room by Lizzo's security guard. Under the watch of the tour's co-manager, the guard allegedly went through Davis's phone and iCloud to confirm whether the recording had been deleted. Davis claims she was scared and wanted to leave the room, which is why she agreed to having her phone searched. She states that she felt she could not leave, however, until her phone was searched. Currently before the court is defendant's special motion to strike the complaint, which plaintiffs oppose. Okay, there we have it. That is the judge's summary of what he is going to take into consideration on this motion. And he said that the reason he's considering these specific facts is that he's reviewed all of the declarations that were submitted. He found that the declarations submitted by the plaintiffs tended to support the allegations in the petition. And so for the most part, he's included those facts. And then to the extent that the defense has asserted that those facts are false, he has then made a note of that in the factual statements. Okay. This is really interesting. The court says this matter was previously on before the court on November 22nd. At that point, the court requested that the parties provide additional authority interpreting language contained in Lyle v. Warner Brothers Productions regarding the viability of sexual harassment claims where no disparate treatment or impact was alleged. The parties have submitted their list of cases, and the matter is now ripe for resolution. So that's going to be one of the issues that the judge is going to consider here, is that in essence, we have a claim of hostile work environment and failure to prevent hostile work environment, but all of the people involved are all females for the most part. We do have the bus driver who was certainly a male. That was a fact that was admitted. But for the most part, this is not your typical sexual harassment case where you either have same-sex sexual harassment or opposite sex sexual harassment. Mostly, this is just a bunch of facts that talk about a sexually charged work environment. And that in and of itself does not make a good sexual harassment claim. Let's see what the judge has to say about it. So the judge goes for many pages, and I'm going to spare you with most of this or some of this, but essentially he says that the defendants have submitted 20 declarations with their motion to strike, and then the plaintiffs objected to every single one of those declarations. And so in reply to those, the defendants responded, and the court really has kind of a mess on its hands right now. So this is what he says about the evidence that he's reviewing, specifically these declarations. He says, as defendants are likely aware, the number of declarations submitted here was unnecessary. One declaration by a person with personal knowledge detailing the relevant situation is sufficient on a motion where the standards for summary judgment apply. The court observed that the defendants emphasized the fact that they submitted 20 declarations in reply, but this is not a numbers game. As long as plaintiffs submit one declaration that disputes the material facts in defendants' 20 declarations, the burden on the second prong is satisfied. Accordingly, the number of declarations is of no moment to the court at this stage. Indeed, even at trial, jurors are instructed not to make any decisions simply because there are more witnesses on one side than the other. If you believe it is true, the testimony of a single witness is enough to prove a fact. That is all the more pertinent here, where, as discussed below, the court cannot weigh the evidence as jurors must. The court can make an educated guess as to why so many declarations were filed. The court would ask that such not reoccur unless there's some kind of legal justification for it. No more need to be said on that point at present. The judge just scolded the defense, right? The judge basically said you submitted 20 declarations to try to make it seem like what you were saying was more true when you know that that's not what the standard is. So this is the judge essentially giving the defense a hand slap. Equally troubling, defendants' approach resulted in an avalanche of evidentiary objections by the plaintiffs. The court has reviewed the objections. The vast majority are at least partly made on the basis of relevance. The court disfavors such objections. By definition, if the proffered evidence is irrelevant, then it can have no part in the court's analysis, objection or not. On the other hand, if the evidence is relevant, then the objection is not well taken. This is not to say that the evidence in question is in fact relevant and material to the court's analysis. It's only to say that if it is discussed below, then by definition, the court finds that it is relevant, although not necessarily weighty or dispositive. If it's not discussed below, then it forms no dispositive part of the court's reasoning and the objection is moot. The parties should refrain from making relevance objections in motions in the future absent some good grounds to do so. And interestingly, a relevance objection is never waived in motion practice. It is error for the court to consider evidence that has no probative value, whether or not an objection is made. So here, the court is slapping the plaintiff's hands and saying, look, the defense submitted all these declarations. You filed all of these motions about relevancy. I don't need you to object to relevance. I'm a judge. I know what's relevant and what is not relevant, and I'm going to consider what I need to consider. And we don't need to create more work for ourselves than there already is. So he's now essentially turned to the plaintiffs and slapped their hand. Aside from that, the court will not rule on the individual objections. Many of the objections are immaterial evidence. Plaintiffs are reminded of our Supreme Court statement in Reed versus Google that only meritorious objections should be raised, and even then, only to evidence that makes a difference. Here, the objections do not meet that standard and constitute the blunderbuss objections to virtually every item of evidence that the Reed court explicitly warned against. Any meritorious objections are lost within the pages of unmeritorious objections. This is not to say that the court has accepted defendants' evidence carte blanche. Many of the declarations contained hearsay and statements without foundation or personal knowledge. The court has not considered statements that suffered from these defects, but that does not leave a hole in defendants' evidence, for generally there was at least some evidence for each of the material points made by the defense, and the court does not weigh the evidence at this stage. Defendants also filed evidentiary objections in reply. The court declines to rule on defendants' numerous objections to immaterial evidence for the same reason. With that said, where the material portions of the declaration suffer from issues of personal knowledge, like one plaintiff attesting to something another plaintiff experienced, the gap is easily filled because the plaintiff with personal knowledge also submitted a declaration detailing their point of view. The declarations are not conclusory, as they provide sufficient explanation for why plaintiffs felt the way they did or perceived certain actions as pretextual. For the same reasons, the declarations are not speculative. Most of the hearsay objections lack merit, as some statements are by people authorized by the party to make statements. Those that have merit are rarely to material evidence. Not sure what he was intending to say there. Okay. That's a lot of basically the court, slapping the hands of each of the parties about how many declarations were submitted, how much motion practice was unnecessary, the content of those declarations containing stuff that's clearly not allowed to be in there. And the judge is just not happy with either of them. He goes on to say that leaves the objection to the jury, meaning the jury. Plaintiffs do not specify where they executed that declaration and only end with, I declare under penalty of perjury for the state of California that the above is true and correct. Defendants argue that this violates the Code of Civil Procedure. The place of execution is missing, but the court believes there's substantial compliance, and then they cite a case in which the Supreme Court undertook a detailed analysis of Section 2015.5's amendments. It noted that the legislature expressly required that all declarations, regardless of where they were signed, state that they would be subject to California's perjury laws. We need not to decide whether, in order to sustain a California perjury conviction, a declaration signed outside the state must be made under the laws of the state of California. The critical concern here is that such language is necessary for validity and admissibility purposes. When the legislature clarified the extraterritorial reach of the perjury state, it also sought to enhance the trustworthiness of out-of-state unsworn declarations used in California proceedings by maximizing the declarant's specific understanding that his false promises to tell the truth carried the potential for criminal prosecution in California. After conscious reflection on the issue, the legislature achieved this purpose by inserting a requirement that whenever an unsworn declaration was made elsewhere for use here, the document must acknowledge on its face that the statements it contained were made under penalty of California's laws. We can only conclude that an out-of-state declaration, which materially deviates from Section 2015.5 in this regard, cannot be used as evidence. Here, all three declarations declare that they are made subject to California's perjury laws. That substantially complies with the Section 2015.5's requirements. The court's long understanding has been that where the location of the execution is blank, the declaration is nonetheless valid so long as it specifies that it is subject to California's perjury laws. The more typical language is under the laws of the state of California, rather for the state of California, but the court interprets that difference to be immaterial. From the court's perspective, the declarants have placed themselves under penalty of perjury under the laws of the state of California, and essentially for that reason, the judge is saying these declarations that were in this form are still valid. Okay, that was a whole thing in and of itself. I think essentially the judge was wanting to make sure that he covered all basis on potentially an appealable issue where he was reviewing a declaration that was potentially not in the proper form. He said, look, this is form over substance. You can't just try to defeat the whole evidentiary value of this declaration by making some sort of trivial form argument, because it in essence complies with the law, and that's what he cares about. Okay, so now what we've gotten out is the judge's recitation of all the facts, him dishing it out to the defense, saying that they've done too much stuff wrong. The plaintiff's got a little bit of ire as well. He gives a little bit of credence to possibly a form argument, but then dismisses it. And now he's going to go into what are the legal standards that he is going to use to review the motion to strike and make his decision. So now let's move on to the legal standards section. The California legislature has authorized that a special motion to strike may be filed in lawsuits that seek to, quote, chill the valid exercise of the constitutional rights of freedom of speech and petition for the redress of grievances. The civil procedure provides a cause of action against a person arising from any act of that person in furtherance of the person's right of petition or free speech under the United States Constitution or the California Constitution in connection with a public issue. The California Supreme Court has summarized the analysis as follows, quote, "At that stage, we said, the moving defendant must identify the acts alleged in the complaint that it asserts are protected and what claims for relief are predicated on them. In turn, a court should examine whether those acts are protected and supply the basis for any claims. It does not matter that other unprotected acts may also have been alleged within what has been labeled a single cause of action. These are disregarded at this stage. So long as the court determines that the relief is sought based on allegations arising from the activity protected by the statute, the second step is reached with respect to these claims. If the defendant makes that threshold showing, the burden then shifts to the plaintiff to establish a likelihood of prevailing on the complaint, which has sometimes been referred to as, quote, minimal merit. The burden on the plaintiff is like the burden imposed to defeat a summary judgment motion. The plaintiff must submit admissible evidence showing that it can prevail. The court does not weigh the evidence or determine issues of credibility, nor does it resolve any factual disputes. Rather, as in a summary judgment motion, if the plaintiff can put forward evidence that, if true, would establish its claim in light of all reasonable favorable inferences, then the the motion to strike will be denied. Such is not intuitively obvious from the statute's language. The legislature's words are that the motion is to be granted unless the court determines that the plaintiff has established that there is a probability that the plaintiff will prevail on the claim. An unadorned reading of that language might suggest that the court is to weigh the evidence and determine whether plaintiff is more likely than not to win, but such is not the law. Consistent with notions of due process and fair access to the courts, this language has been authoritatively construed to mean that there must be some probability of success, but not in the more likely than not sense. Rather, all the court must determine is whether there is some probability, meaning the plaintiff has put some evidence forth, and that if that evidence was believed, it would be sufficient to allow a jury to find in favor of the plaintiff. The court notes that where this law applies, it is a potent tool. Once brought, discovery is generally stayed until the motion is heard. Unlike a summary judgment motion, which is typically brought after discovery and which can or must be continued if the opposing party makes a showing that discovery might yield evidence to defeat the motion, a motion to strike presumes that the plaintiff already has some evidence to support the claim. Further, a summary judgment motion, if denied, is reviewable only by writ. It generally becomes moot after the trial is over, either because the moving party won or because it was overtaken by the actual trial evidence. In sharp contrast, the court's ruling on an SMS is immediately appealable. The court notes that point because it well explains why it is that the court cannot weigh evidence. If the court were allowed to do so, the SMS would quickly become a substitute for a jury trial and would so become in a way that would imperil due process. Thus, the court's power is sharply circumscribed in such a motion. That said, if the complaint lacks evidentiary support in whole or in part, the court can and must strike it or the offending parts of it. So that is the legal analysis, that is the legal holding, interpreting this anti-SLAPP statute and saying how the anti-SLAPP statute is going to be applied to the facts of this case. He always, or in any order that you're going to see from a judge, it's always going to start with this facts that they have determined are relevant, followed by what legal analysis that they are going to apply, and then we are going to get into the good stuff, the ruling and the analysis. So get ready. You might want to get a cup of coffee for this part. You'll remember that in essence, the defendant moved to strike almost the entirety of the plaintiff's complaint. The allegations concern all 9 causes of action and can be split into general categories of wrongful conduct as discussed below. If the motion is granted in full, the court believes there's really nothing left of the complaint and that an outright dismissal would be in order. So what he's saying is, in essence, if we were to give the defense what they're asking for, that would be it. This case would be over. And the judge is now going to look at each part of the causes of action and analyze each using this anti-SLAPP 2-prong approach. Okay. Starting with acts in furtherance of the defendant's right of petition or free speech, prong 1. So again, if the acts involved an exercise of the defendant's free speech rights, then it is protected action, and that causes the court to then look more critically about whether plaintiff has stated enough facts or presented any evidence which would allow it to prevail at trial. Okay, so how do we determine that, right? Like in the anti-SLAPP context, the critical point is whether the plaintiff's cause of action itself was based on an act in furtherance of the defendant's right of petition or free speech. In making its determination, the court shall consider the pleadings and supporting and opposing affidavits stating the facts upon which the liability or defense is based. Defendants argue that the acts complained of in the original complaint all consist of activity that is part of the creative process, and therefore it's all protected. Subdivision E4 protects, quote, any other conduct in furtherance of the exercise of the constitutional right of petition or the constitutional right of free speech in connection with a public issue or issue of public interest. What constitutes a statement made in connection with an issue of public interest is the same under subdivisions E, 3, and 4. And that's precedent that they're citing from this Ducharme versus International Brotherhood case. There's another 2-step test to determine this. So basically now we have a test within a test, right? So there's a test within the first prong of the anti-SLAPP motion. And that test is, we ask what public issue or issue of public interest the speech in question implicates. A question we answer by looking to the content of the speech. Second, we ask what functional relationship exists between the speech and the public conversation about some matter of public interest. The defendants insist that the television show and Lizzo's own fame are within the realm of public interest. Here, the Court of Appeal properly identified 3 non-exclusive and sometimes overlapping categories of statements within the ambit of subdivision E4. The first is when the statement or conduct concerns, quote, a person or entity in the public eye. The second, when it involves, quote, conduct that could directly affect a large number of people beyond the direct participants. And third, when it involves a topic of widespread public interest. Defendants point out that Lizzo's concerts, television shows, and public statements on certain issues are in the public interest due to her status as a major celebrity. The court agrees. In Nygaard, this court held that, quote, an issue of public interest is any issue in which the public is interested. In other words, the issue not need to be significant to be protected by the anti-SLAPP statute. It is enough that it is one in which the public takes an interest. Plaintiffs argue in opposition that Lizzo's status as a celebrity alone is insufficient because there can be no claimed public interest in cast meetings and outings, prayer groups, or other things like that. Stripped of context, plaintiffs are correct. But when the issue becomes Lizzo's cast meetings and outings, prayer groups, and things like that while on tour, the analysis is very different. It is Lizzo's celebrity that elevates these perhaps mundane issues into the average citizens want to know more about, into those that the average American or average citizens want to know more about. Then they refer to this case in which they pull this piece of law. The public's fascination with Brando and widespread public interest in his personal life made Brando's decisions concerning the distribution of his assets a public issue or an issue of public interest. Although Hall was a private person and may not have voluntarily sought publicity or to comment publicly on Brando's will, she nevertheless became involved in an issue of public interest by virtue of being named in Brando's will. The court believes that the first step of the film on analysis is satisfied. So the judge is giving the defense team a pretty large victory here, but I think he's made kind of a caveat in it. So if we look at this, he's saying, while he is going to go with the defense on the fact that Lizzo's personality, relates to the public interest because she is a major celebrity. So he's trying to make a distinction that just because Lizzo is a celebrity is not enough, but to the extent that Lizzo is on tour and is having cast meetings and outings, prayer groups, and other things like that while on tour, the analysis of those types of things is different than if she's not on tour. So he is putting definitely some stock in the fact that if the activity occurred on tour, it deserves this anti-slap protection, this greater protection. As to the second film on step, defendants assert that acts that further the creative process are protected. Courts have held that acts that advance or assist the creation and performance of artistic works are acts in furtherance of the right of free speech for anti-slap purposes. This is true, but defendants' argument overstates the connection between certain acts and the creative process. While many of these acts occurred during a tour and in preparation for it, that alone does not satisfy the second film on step. The second step requires a consideration whether a defendant, through public or private speech or conduct, participated in or furthered the discourse that makes an issue one of public interest. And then he quotes, "We reject the proposition that any connection at all, however fleeting or tangential, between the challenge conduct and an issue of public interest would suffice to satisfy the requirements of Section 425.16. At a sufficiently high level of generalization, any conduct can appear rationally related to a broader issue of public importance. What a court scrutinizing the nature of speech in anti-slap context must focus on is the speech at hand rather than the prospects that such speech may conceivably have indirect consequences for an issue of public concern. Accordingly, the analysis needs to be more granular. Thus, while the court understands the argument and agrees that the fact that the case involves a well-known mega celebrity brings a lot of conduct into the constitutionally protected ambit that would not otherwise be there, it is not without bounds. The court must look closely at the actual things alleged and the evidence presented to determine if it's fairly within or outside of constitutionally protected speech or the public interest." I mean, again, what he's saying is there is a test within a test, right? There's a legal test within the first prong of the test. But generally, he's saying the defense has used this very broad brush and says everything that Lizzo does, because she's a mega celebrity, is protected. And what the court is saying here is actually no, we have to get into a more granular review and go allegation by allegation to determine whether or not that act was in furtherance of Lizzo's free speech rights. Okay. It is worth identifying which purported protected acts supply the elements of plaintiff's various causes of action. The first and second causes of action for FEHA violations concern sexual harassment and failure to prevent sexual harassment. Plaintiffs claim defendants were forcing Davis and Williams to participate in the nude photo shoot and causing plaintiffs to attend news shows against their will at the Banana Bar and the Crazy Horse, as well as Quigley's charged comments about Davis's virginity, sexual statements, and gestures on tour. Finally, plaintiffs also claimed that they suffered sexual harassment by a tour bus driver and male crew members. The third and fourth causes of action for FEHA violations concern religious harassment and the failure to prevent it. The acts that supply the element of wrongful conduct here include Quigley's statements on religion and sexuality, as well as proselytizing to the members and conducting forced prayer circles prior to rehearsals and performances. The fifth cause of action for racial discrimination in violation of the FEHA focuses on statements describing the Black members of the dance team as lazy, unprofessional, and having a bad attitude. The sixth cause of action for disability discrimination in violation of the FEHA concerns the private personnel meeting between Davis, Lizzo, and Scott. Davis's anxiety during the re-auditioning process that made her feel like she had no choice but to urinate on herself, and Lizzo's statements that weight gain is grounds for termination from the dance team. The seventh cause of action for intentional interference with prospective economic relations is based on statements by tour management and BGBT accountants that plaintiffs should remain on a, quote, soft hold while they were on break from touring. The eighth cause of action for assault concerns Lizzo's statements and conduct towards Rodriguez after her resignation. The ninth and final cause of action details Davis's confinement by tour management and security while they confirmed the meeting recording had been deleted. Defendants contend that all of the allegations supporting all of the causes of action concern the creative process. The nude photo shoot they assert took place during filming on Watch Out for the Big Girls to choose dancers for the tour, and that providing feedback on dancers or terminating employees who were not up to par is encompassed within that process, and the court agrees. The creation of a television show is an exercise of free speech. Hiring and firing dancers for a television show and event tour is also part of the creative process. Music as a form of expression and communication is protected under the First Amendment. A singer's selection of the musicians that play with him both advance and assist the performance of the music, and therefore is an act in furtherance of his exercise of free speech rights. Thus, the nude photo shoot is protected, and the plaintiffs do not really challenge that or certain other acts. The court believes this protection extends to providing feedback to dancers during various meetings, as well as the re-audition process. All of this is part of the creating the performance that the artist envisioned in her head. The private meeting with Davis is also protected. As alleged, as the evidence support, the meeting centered around Davis's personality changes during the tour. Davis alleges that it was feigned concern and was a veiled reference to her weight gain. Maybe so, but the allegations still indicate that this meeting was related to Davis's job performance on tour. Lizzo attests that she worried that the tour was too much for Davis and wanted to check in with her. This bears a relationship to Davis's health on tour and, according even to plaintiffs, Davis's job safety. The soft hold and comments within the context of retainer negotiations are also protected. When dancers are on break between performances and not on retainer, tour management will sometimes be informed about dates dancers might be working on the tour in the future and will therefore ask the dancers to be placed on a soft hold for those dates. The idea is to keep those dancers available for the tour. The negotiations for a soft hold retainer are protected because they concern staffing for a tour. Joshi's comments during the negotiations are protected because they communicate lax job performance during concerts and note that this is grounds for termination. Production of a show and personnel decisions related to that are protected. The same applies to comments calling Black members of the dance team lazy, unprofessional, and snarky. While the comments are alleged to be racist, the court cannot let plaintiffs' allegations of motive control the analysis of the first prong. On the first prong, the court simply examines the conduct of the defendants without relying on whatever improper motive the plaintiff alleged. So, To conclude otherwise would effectively shift to the defendant a burden statutorily assigned to the plaintiff. If acts are protected, it is for the plaintiff to establish that there is a probability that the plaintiff will prevail on the claim. These comments were purportedly made by management within the context of retainer negotiations and the tour. Comments on job performance are in furtherance of the creative process. The prayer circles also pass the first prong, although in the court's mind, it's a closer call. There's more than one declaration indicating that this is an industry practice or it's meant to settle nerves prior to a performance. I'm usually backstage with the stage performers and Lizzo before each show. The group prayer led by Lizzo before the show is primarily a way for everyone to connect and with one another and to touch base in preparation for their performance, while also seeking protection and safety for everyone who put on the show and everyone attending. That bears a functional relationship to the creative process. Quigley's religious and sexual comments during rehearsals are more difficult. As noted above, plaintiff's allegations regarding Quigley's intent do not control. But even with that said, the court does not understand how the comments are connected to the creative process. Defendants generally argue that it is part of the creative process, which is fine to the extent that these comments are made during dance practice by a dance team captain. But if, as plaintiffs point out in the opposition, there has to be more. It's not enough that the comments were made during the general creative process. The actions at issue must advance the creative process. There's nothing from these bare allegations regarding Quigley's comments about religion and sexuality that indicate that they advanced or assist the dancer's performance. Notably, not a single one of the 20 declarants states that the comments contributed to the creative process. There are comments on how this was part of girl talk and that the plaintiffs have taken it out of context. The reality is that we were a group of women who were all together all the time, traveling, rehearsing, socializing on tour, and we talked about girl talk, including things like our sexuality. We did not talk about this all the time, but it was certainly a topic that we covered. Quigley joined these conversations too, but she certainly did not talk about sex, sexual acts, or sexual fantasies all the time. But saying it's, quote, girl talk or that plaintiffs are not telling the truth does not equate to furthering the creative process. Defendants have not met their burden as to this facet of the complaint. The same applies to Quigley's purported proselytizing during the tour. All the declarations that mention Quigley studying ministry indicate that this was a personal choice and was not related to the production of the tour. Quigley's own declaration emphasizes her discussions about her faith took place mostly during breaks. I'm a Christian and vocal about my love of Jesus. For the past 2 years, I have been studying ministry, and for the past 9 months, I have been working on setting up a faith-based nonprofit organization. On breaks while on tour, I would often sit and read the Bible as part of my studies. Sometimes other dancers asked me what I was studying, and about my faith and about my past. Some of Lizzo's dancers believed in Jesus and some did not. That did not affect how I treated or interacted with them. There is no functional relationship. In short, Lizzo's status as a celebrated performing artist may make some of what happens related to the tour matters of public interest when they would otherwise not be, but that extension is not infinitely elastic. So what the judge is saying there is that's a bridge too far. You know, we're willing to say that anything that Lizzo does in relation to preparing for the tour or as part of the tour or as practicing or as part of that creative process is protected, which they say pretty much most of the things are protected, which is a pretty huge win for the defense, except as to Quigley. He is not buying it with regard to Quigley and basically says that's a bridge too far. There's also no articulated functional relationship between the creative process and failure to address sexual harassment by the bus drivers. Gordon provides her recollection of the event, but does not connect it to furthering the creative process. My recollection of what we were told about the alleged incident was that Williams accidentally bumped into a tour bus driver who told her in a suggestive way that she could do that again. Gugliotta and I took the complaint very seriously. I am informed and believe that Gugliotta spoke with the lead tour bus driver about the incident and requested that he speak with the driver in question to ensure this type of behavior did not happen again. To my knowledge, the bus driver did not engage in any other alleged misconduct. Certainly no other issues with this bus driver or additional alleged incidents of sexual harassment by him or any other driver were ever reported to me thereafter. In fact, I followed up with the plaintiffs and the other female dancers in the dance cast about the bus driver and the alleged incident that had been reported about his conduct, and I asked whether there had been any other incidents. They assured me that everything was okay. I thanked them for bringing the incident to our attention and told them to let me know of any other incidents of inappropriate behavior. None of them did. It is defendants' burden to articulate how this relates to advancing or assisting in the creative process, but they have not met their burden. To the extent that they intend to argue that the safety of the staff is key, there is nothing linking safety to the creative process, at least in the moving papers. The court also does not see the functional relationship between the Banana Bar and the Crazy Horse and the performances. Plaintiffs allege that it was voluntary in name, but not in reality. Lizzo attests that these events are team building so that everyone can spend more time together in a relaxed environment. She adds that the Crazy Horse invitation was meant to inspire the dancers, the creativity, and improve the overall performance of our show. Lizzo notes that other major stars such as Beyonce have incorporated elements from the Crazy Horse show. The court is not sure how voluntary off-the-clock time at a club bears a functional relationship to the performance of a set dance routine. Of course, the court understands it as a general matter in that seeing others can inspire a person to work harder or lead to new ideas. I also believed that attending the show would be helpful to the dancers, particularly those who are newer to the industry, so that they could watch how the Crazy Horse dancers move their bodies and gain more confidence and self-assurance themselves. At least one declarant says that these events helped improve the show because everyone could bond. It definitely helped bring the performers closer together and helped improve our shows because we had these occasions to bond. But this activity was, according to the defendants, voluntary. Not all the dancers were required to attend clubs to aid their performance of pre-choreographed numbers. Given that, the court is not sure how something that no one had to say no to, according to the defendants, is going to aid in the creative process. Further, Lizzo's declaration as to her intent undercuts the defendant's theory. To be frank, I was enjoying a night out at Banana Bar with friends and did not have any expectations about who would attend or how long they would stay. The functional relationship between this voluntary off-the-clock club activity and the concert performance is missing. Okay, so all of the allegations about the Crazy Horse and the Banana Bar are going to stay in. Again, going back to the very, very first paragraph, are we going to rise to the level of sexual harassment? I don't think so. Why? Because a sexually charged environment does not sexual harassment make. Okay, that leaves the false imprisonment and the assault actions. Those also do not meet the functional relationship test. Running through a person's phone and coercing them not to leave while doing so in order to delete an audio recording bears no relationship to the performance of a concert, and the defendants articulate no such relationship. The same is true of attempted assault, and the fact that it took place during a meeting with the dancers on tour does not mean that there is an automatic relationship. Without more, arguing with somebody or attempting to hit them does nothing to further the creative process. Given the above analysis, the defendants satisfy their burden on the first prong in part. The motion is denied, however, as to the allegations regarding Quigley's religious and sexual comments, management's failure to address sexual harassment issues, attendance at the Banana Bar and the Crazy Horse, Davis's false imprisonment, and Lizzo's purported assault. This necessarily means that the motion is denied to the 8th and 9th causes of action, the course does not discuss them on the second prong analysis. The burden shifts on the remaining allegations. The reason that is because he's finding that those had absolutely nothing to do with the creative process, and so those are going to stay in regardless. With regard to the first prong, now we have to go to the second prong, right? So he's saying definitely staying in are the false imprisonment and the assault. Now we're going to look at what happened on whether the plaintiffs will be successful on the claim. So if defendant makes a threshold showing that the challenged cause of action is one arising from protected activity, the burden shifts to the plaintiffs to establish a likelihood of prevailing on the complaint. Now, again, what the judge says in the legal standard is that doesn't mean that you're more likely than not to succeed. It simply means, do you have any evidence that would support your cause of action? Okay. The plaintiff must demonstrate that the complaint is both legally sufficient and supported by a sufficient prima facie showing of facts to sustain a favorable judgment if the evidence submitted by the plaintiff is credited. So if a jury were to believe the testimony of these three plaintiffs, would they likely succeed on their causes of action? That's what he's going to look at. So again, the court's not going to weigh the evidence. They're not going to say this declaration says this and this declaration says that, and we believe this one more than that one. The judge is simply going to say, is there any evidence here to support these causes of action that remain? And so the first one is going to be the sexual harassment. Let's look at that. Sexual harassment requires a showing of at least three things. The first thing is that you were subjected to unwelcome sexual advances, conduct, or comments. That one I think we have. The harassment was based on sex. Well, I don't think the harassment here was based on sex. The reason, there is really nothing based on sex here other than with regard to the bus driver. That's the only thing where the bus driver is hitting on her because she's a female. The other girl talk stuff is not that. It's not based upon their sex. It's simply all of the girls talking about sex. The harassment was sufficiently severe or pervasive to alter the terms and conditions of the employment and to create an abusive working environment. Now, that I think they could possibly meet, but I don't think that they're going to meet the harassment based on sex portion, except with regard to the bus driver. So let's see what he says. On that particular issues, plaintiff points to Davis's declaration where she attests that participating in the nude photo shoot caused her to panic and made her feel terrified. This news photo shoot challenge was part of the competition, and I believed poor performance or outright refusal to do the challenge would have resulted in me being viewed as a non-team player, penalize the image Lizzo had of me, and no longer be considered for a spot on Lizzo's tour. This dilemma forced me to decide between a once-in-a-lifetime opportunity and putting my body on display. After footage was seen of me crying and panicking, I was informed that I would be allowed to participate in the photo shoot, partially clothed in a nude bra and nude underwear. This was my first experience of a sexually charged and uncomfortable environment in Lizzo's camp. One of the issues the court discussed at oral argument was the question of Lyle's court language. Okay, bringing it back to Lyle, which was the very first point that the judge makes. For FEHA claims, the discrimination requirement has been phrased similarly. To plead a cause of action for hostile work environment, sexual harassment, it is, quote, only necessary to show that gender is a substantial factor in the discrimination and that if the plaintiff had been a man, she would have been treated in the same manner. Accordingly, it's the disparate treatment of an employee on the basis of sex, not the mere discussion of sex or the use of vulgar language, that is the essence of a sexual harassment claim. And that's what Lyle says. Specifically, the Lyle court, after noting that the FEHA and Title VII use the same hostile work environment sexual harassment standard, and citing the U.S. Supreme Court's opinion in Oncal versus Sundowner, as providing guidance on the element of harassment due to sex. Rather, the critical issue is whether members of one sex are exposed to disadvantaged terms or conditions of employment to which members of the opposite sex are not exposed. This means a plaintiff in a sexual harassment suit must show, quote, the conduct at issue was not merely tinged with offensive connotations, but actually constitutes discrimination because of sex. Parallel citations omitted, emphasized by the on-cal court. Okay, this is what I've been saying, right? The mere sexually charged work environment does not create a hostile work environment. I think based upon this, it's very clear that the judge is going to make a determination that the sexual harassment claims are coming out. Except, I bet, he's going to leave in the sexual harassment claims relating to the bus driver. So let's look at that. Okay, and he's looking at the other court precedent of the other courses, of the other that were provided by the plaintiffs. And essentially he's saying Lyle is where it's at. None of these other cases, they overlap, but at the end of the day, Lyle stands and, quote, if our precedent leaves any doubt on the question, we hold today that nothing in Title VII necessarily bars a claim of discrimination, quote, because of sex, merely because the plaintiff and the defendant are of the same sex. We see no justification in the statutory language or our precedents for a categorical rule excluding same-sex harassment claims from the coverage of Title VII. However, the on-cal court was clear that the plaintiffs still need to present some evidence of harassment due to their sex. And then they go on to cite the precedent that was set forth in on-cal, which essentially says the reason that you're being discriminated against has to be on the basis of your sex. So again, the court is sorting through each of the cases. They are setting forth its analysis that, common sense and an appropriate sensitivity to social context to distinguish between simple teasing or roughhousing among members of the same sex and conduct which a reasonable person in the plaintiff's position would find severely hostile or abusive. Some of the cases cited by the parties put this varied evidentiary burden on display. One landmark California Supreme Court case, Miller, demonstrated that widespread sexual favoritism of certain employees could create a hostile work environment for non-favored employees because the favoritism implied that women were sexual playthings and the only way to get ahead was to have sex with the manager. This, the court held, created an atmosphere demeaning to women. Singleton and Taylor held that the plaintiffs were subject to the same-sex sexual harassment because their identities as heterosexual men were attacked by other men in the workplace. Putting this point another way, given that Ross and Umi had targeted Singleton's identity as a heterosexual male, it is axiomatic that they would treat women differently, i.e., not attack them for the same reason. It follows that the harassment was, quote, because of sex. It employed attacks on Singleton's identity as a heterosexual male as a tool of harassment. The Taylor court emphasized, however, that the attacks do not need to be motivated by sexual interest or desire to be actionable under FEHA. Lewis held that same-sex harassment claims were proper where the plaintiff was subject to sexual advances, conduct, and comments that stemmed from the defendant's sexual interest in the plaintiff. In Sharp, the Ninth Circuit held that both men and women could complain of a hostile work environment, which makes sense. So again, all of this gets down to the fact that it can't just merely be a sexually charged environment, but each of these little bits of precedent that the court is bringing up and is inserting into its opinion build on themselves. And they build this notion that you simply, it doesn't relate to just an environment of sexual comments, girl talk, etc. It really has to be that you are discriminated against in that setting, or that you are suffering some sort of negative action as a result of your either failure to participate, you're being discriminated on the basis of you're not engaging in that sexual activity or sexually charged environment. And this is where the judge says it best. These cases illustrate that there are a variety of ways to establish discrimination due to sex, but as is likely clear from the summaries, none of these evidentiary methods apply here. There is no indication of any sexual interest in the plaintiffs, nor any widespread sexual favoritism, so those evidentiary avenues are closed. There's no evidence indicating that plaintiffs, and Davis in particular, have been treated differently due to their sex, or that men would have been treated differently as to the portions of the motion that made it to prong two. Not a single one of the plaintiff's declarations states as much or even supports that interference, nor is there any evidence indicating that the female defendants were motivated by a general hostility to women in dealing with plaintiffs. Both Lyle and Oncal are clear that there must be some evidence of discrimination due to sex, and there is none here. The motion is granted as to the nude photo shoot allegations in the first cause of action. Okay, this is, I think, a good decision, right? The nude photo shoot, at the end of the day, she didn't like it. She felt like it was uncomfortable, but she wasn't discriminated as a result of not doing it. And ultimately, there was not some sort of quid pro quo or any disparate treatment between her and the other dancers. So I think the judge totally nails it here. All right, second cause of action, failure to prevent sexual harassment. There can be no claim for failure to take reasonable steps necessary to prevent sexual harassment when an essential element of sexual harassment liability has not been established. So as to the nude photo shoot, because there was no sexual harassment, it cannot be included in the second cause of action, which is failure to prevent sexual harassment. Now, notice he's only making that about the photo shoot. We haven't heard about the bus driver yet. So let's think about that and hold on to that one. All right. The third cause of action is religious discrimination. As you will recall, the judge said that's not a part of the free speech rights of Lizzo. It really related to Quigley and had nothing to do with the performances. And so with regard to the religious discrimination, the only act plaintiffs need to address in this cause of action is the prayer circles. There are three elements to a prima facie case for religious discrimination. The first is that the employee sincerely held a religious belief that the employer was aware of, and the belief conflicted with an employment requirement. Preliminarily, the court observes that this cause of action is more accurately described as, quote, reverse discrimination. No, what Rodriguez says is that she does not a believer of Christianity, and she believes that she was kind of forced to participate in these prayer circles, but it's not that she was a Muslim and was discriminated against on that basis. Here, it's more accurate to say that she is a non-believer, right? The court is unaware of any published California case on this type of claim. However, there is federal authority indicating that such a claim is viable, and in that situation, the plaintiff need not establish that they were part of the protected group. The analysis in these cases makes sense to the court. For that reason, the court does not believe plaintiffs must establish that they are part of a protected group on the basis of religion when alleging reverse religious discrimination. Plaintiffs satisfy their burden. They present evidence that Quigley and others were aware of the fact that they did not share their religious beliefs. Despite knowing this, prayer circles prior to rehearsal or performances were essentially mandatory, even if a person did not want to partake. Rodriguez specifically attests that when she stated she did not want to lead the prayer circle because this practice made her uncomfortable in a work setting, she continued to be singled out by staff like Melissa Charlotte. Plaintiffs also satisfy the element that the belief conflicts with an employment requirement. Plaintiffs were allegedly required as a practical matter to attend the prayer circles, even if they did not want to, and even if they spoke up like Rodriguez did. The court is aware, of course, that the defense has submitted contrary evidence from multiple declarants. But as discussed above, the court does not weigh evidence. The question is not whether plaintiff's evidence is stronger than the defendant's evidence or whether plaintiff has more declarations or fewer. It's whether plaintiff has some evidence that, if believed, would be sufficient. Once that threshold is met, the court's analysis ceases. So, in reply, the defense argued for the first time that all of the plaintiff's FEHA claims fail because the FEHA does not apply outside of California. The salutary rule is that points raised in a reply brief for the first time will not be considered unless good cause is shown for the failure to present them previously. The court will not address this argument as it was raised for the first time in the reply, despite facts in the complaint indicating that offensive conduct occurred out of state and out of the country. This applies to all of the FEHA claims. So this is true regardless, guys. No matter what, your attorney is going to have to make all of their arguments in their initial opposition. You can't bring up stuff in your reply. You have to address it on the front end. And if you don't address it on the front end, it's deemed waived. So that's what the judge is saying here. All right, next the defendants reiterate what they say in their moving papers. The evidence is against the plaintiffs. Defendants cite their declarations indicating that the prayer circles were voluntary and no one was pressured into joining them. Finally, the defendants argue that even if the conduct occurred, it was not pervasive enough to be actionable. That might or might not prove to be the case. For purposes of this motion, though, the court believes the plaintiffs have put forth enough evidence to live to fight another day. The motion is denied as to this cause of action. We have religious discrimination that stays in. The judge is saying that the religious discrimination, we can get into it later, but there's enough here based on Rodriguez's declaration that he's going to keep the religious discrimination in, which also means failure to prevent religious discrimination should also stay in. Let's see. Number 4, employers are required to take all reasonable steps to prevent discrimination in the workplace. Plaintiff points out that supervisors led this activity, and that is enough. Rodriguez and Williams identified Charlotte as leading at least one prayer circle and pushing back when Rodriguez did not want to take part. Charlotte is the assistant of Tanisha Scott, who choreographed the routines. Further, Green, Lizzo's personal assistant, attests to seeing Lizzo lead the prayer groups. I am aware of allegations regarding religious harassment and discrimination and dancers purportedly being pressured to participate in prayers. I'm usually backstage with the stage performers and Lizzo before each show. The group prayer led by Lizzo before the show is primarily a way for everyone to connect with each other more deeply and touch base in preparation for their performance. Not only was there a failure to prevent the discrimination, but supervisors took part in the alleged problematic events. The parties spend time arguing about Quigley's actions, but that's not material here, as her comments did not make it past the first prong. Had they, though, the court believes that the evidence would have been sufficient to overcome the motion. The motion is denied to the prayer circle allegations. And what that means is that prayer circles and the religious discrimination stay in, and the failure to prevent religious discrimination with regard to the prayer circles stay in. All right, now we're looking at the racial discrimination. And in order to prove racial discrimination, we have to show 5 things. The first is the party was a member of a protected class. He was subjected to unwelcome racial harassment. The harassment was based on race. So similar to the discrimination being based on gender, here the harassment has to be based on race. The harassment unreasonably interfered with his work performance by creating an intimidating, hostile, or offensive work environment, and the defendant is liable for the harassment. Okay. At issue here, we're talking about the lazy, unprofessional, and snarky, and generally having bad attitudes comments that the management team made about the plaintiffs. Plaintiffs Davis and William present enough evidence to establish that they were subject to racial harassment. They established that they are part of a protected class. They were subjected to unwelcome and racist comments, and they were mostly pointed at Black members of the dance team, and that the harassment interfered with their work environment. These comments came about in response to the dancers' request for a retainer, where Joshi berated them, as well as other instances of such comments by management. In particular, Williams was fired in the hotel lobby where she could be seen by others. Both also attest to increased tension with management, including lashing out at dancers by saying that they were drinking. In reply, the defendants contend that a single email is not sufficient to establish a pervasive atmosphere of discrimination, but it's not just a single email. The two plaintiffs also state that there was increased tension thereafter. Further, Davis states that BGBT management treated the Black members of the dance team wildly different from the other members, for they called us lazy, unprofessional, and told us that we had bad attitudes. These remarks were made by white members in management. The implication is that it happened more than once. Whether that's true is a question for the trier of fact. Frankly, this is not the strongest evidence of racial animus, impact on the working environment, or prevalence the court has ever seen. But in making inferences in plaintiff's favor, it is sufficient. So remember how I told you that we're going to learn a lot about what the judge thinks about the claims? Well, what he's telling them right here is, look, I'm going to leave this in, but I don't think that this is a very strong cause of action. You're going to need to find something else, or you're going to need to go in a different direction. So this is like throwing the plaintiffs a bone, but ultimately I think they've got a real uphill battle on the racial discrimination front. The thing that is interesting to me that has not really been brought up here, and I guess it's because it's not a really big point made in the original petition, is that the soft hold was given to the musicians, who I'm assuming are not all Black women, right? They're certainly not all large Black women of color. I would imagine that is a more racially diverse group of people. But with regard to this all Black group of women dancers, the management team, who is white, were treating them differently when it came to that soft hold. So I don't know if I 100% agree with the judge here. To me, if that was more fully developed, I could get behind seeing that, that there's some more evidence of racial discrimination, particularly relating to the soft hold issue. Okay. Defendant's evidence that other Black dancers did not experience racism only establishes a triable issue of material fact. The court cannot accord more weight to one person's experience on this motion. The motion is denied to this cause of action. Okay, remember how I said everything is all about the footnotes? Let's read this footnote. And it is possible that an industry standard that did not give dancers retainers had its roots in racial animus. The court is not saying that that is the case here, as there's no evidence of that. But these sorts of questions on industry standards or standards of care are typically questions of fact, and the evidence here does not conclusively answer those questions. So, again, the argument that this is industry standard, well, if it's industry standard, but the industry standard is racist in and of itself, it could still be evidence of racial animus. Okay, getting down to disability discrimination, I want to just kind of hit the high notes here. You have to have suffered from a disability or was regarded as suffering from a disability. You could perform the essential functions of your job if you had a reasonable accommodation, and you were subjected to an adverse employment action because of your disability or perceived disability. All right. Does Davis get any sort of bone here? That is the question. Okay. Davis states that she was called into a meeting on April 20th with Lizzo and Scott, at which point she disclosed depression, anxiety, and binge eating. Prior to then, she was performing her job and reiterated to the two that this would not affect her performance. Davis claims that she already felt that this meeting was pretextual and was really about her weight gain, which was caused by her binge eating disorder. Davis was then fired 2 weeks later. If credited, the short lapse between the disclosure of her mental health and Davis's termination would establish adverse employment action due to disability. The issue, however, is intervening conduct. Ooh, this is good. So what he's saying is, if that were the only facts that we had, that Davis discloses that she suffers from binge eating, mental health, and anxiety disorder, and then she's fired 2 weeks later, that might get you in on a prima facie case. However, here, defendants argue that Davis was actually fired for recording a conversation which was in violation of the NDA that she had signed. Davis admits to recording it. She claims that the reason for recording it had to do with the fact that she had this disability. Okay, on May 3rd, Lizzo held another meeting expressing her betrayal that somebody recorded the April 27th meeting and that she was going around the room person to person until she found out who did it. Davis preemptively raised her hand, admitted that she recorded the meeting, and sent it to Williams. Davis was fired on the spot. The temporal proximity between the meeting and Davis's termination is interrupted by Davis's voluntary confession to recording the meeting and sending it to Williams, and the immediate termination of her employment in response. The court emphasizes that the recording of the session would not be enough to overcome plaintiff's showing that the only issue. The court emphasizes that the recording of the session would not be enough to overcome plaintiff's showing were that the only issue. But the fact is that Davis admitted not only recording the session, but also sending it to Williams, who had just been fired by Lizzo. And sending the recording to Williams had nothing to do with any disability. So when Davis says, look, I recorded this meeting because I needed it in order to listen to it back when I was less anxious, or in order to get a better sense of what Lizzo's notes were, that's all fine and good, but you sent it to, you ended up sending it to Williams. And by sending it to Williams, that's it. You have this intervening conduct which occurs, which is a terminable offense. And regardless of whether or not anything had to do with your disability, you've given them a reason to fire you, and they did. So that is why the judge says that with regard to the ADA disability discrimination, that is out. Also is out is the failure to prevent ADA or disability discrimination. Okay, let's talk about what is involved in sustaining that type of claim. First, you have to have an economic relationship between the plaintiff and some third party with the probability of future economic benefit to the plaintiff. The defendant's knowledge of the relationship, intentional acts on part of the defendant designed to disrupt that relationship, actual disruption of the relationship, and economic harm to the plaintiff proximately caused by the acts of the defendant. Just in reading the prima facie elements, you know that this is going to get dismissed. And why is it going to get dismissed? Because the recitation of the facts of the contract between these other third parties are super vague. It's like, hey, I could have work with so-and-so. It doesn't say I have a contract. It doesn't say anything about the viability of that or the probability of that thing. So I think this is coming out for sure. Plaintiffs contend that placing them on a soft hold interfered with their ability to accept other job offers. In order for this claim to be actionable, though, plaintiffs need to identify the existing non-contractual relationship with which defendants interfered by placing plaintiffs on a soft hold. As defendants point out in the reply, not a single declaration identifies any existing relationship. Rodriguez comes the closest, but her declaration makes clear that these were relationships that could exist, not ones that did presently exist. Okay, so that's exactly what I thought. Like, that's coming out for sure. And the reason that it's coming out is these were speculative, possible jobs that they could get, but they never took it far enough. And as the failure to do that, that's what actually ends up tanking their ability to succeed on that claim. And so the judge is kicking that out. Here's our summary. The case presents a number of difficult issues, and although not every allegation involves protected activity or matters of public interest, many do. The courts are rightfully wary of injecting themselves into the creative process. Speech, including entertainment and other forms of expression, are protected rights, and the law wisely disfavors chilling such conduct. Indeed, that is one of the drivers behind the anti-SLAPP statute. On the other hand, the fact that the alleged incidents take place in the entertainment or speech world is no shield of invulnerability or license to ignore laws that are enacted for the protection of California's citizens. Finding the right balance is no easy task, and this case is a perfect example. It's dangerous for the courts to weigh in, ham-fisted, into constitutionally protected activity, but it's equally dangerous to turn a blind eye to allegations of discrimination or other forms of misconduct merely because they take place in a speech-related environment. The court has tried to thread this needle, although the court, being a trial court only, is aware that this is likely only the first stop on this case's journey. So he's already thinking that there's going to be an appeal here, which is pretty interesting. The court also notes that although the anti-SLAPP standard is similar to the summary judgment standard, there are some differences. Summary judgment comes after discovery. Some things are easy enough to allege or even declare, but may not stand up following a review of the documents or crucible of deposition examination. As to the portions of this motion that were denied, the court does not mean to suggest that the defendants are precluded from bringing a summary adjudication motion, either as a legal or practical matter. Of course, the court does not know how it would rule should such a motion be brought. It is only to say that the court's mind as to what the record will show at what stage is open. In light of the foregoing, the SMS, the anti-SLAPP statute motion, is granted as to the nude photo shoot allegations in the first and second causes of action, and is granted as to the sixth cause of action for FEHA disability discrimination, and the seventh cause of action for intentional interference with prospective economic relationship. It's denied as to the remainder. Okay, so there we have it. The judge has weighed in. It sounds pretty interesting. The judge, after reading this, I think is really kind of on the plaintiff's side here. And I think he's giving a big word of caution to the defense that, you know, maybe you've got some smoke and some fire here, but he's also saying to the plaintiffs, some of these things just barely passed this muster, you know, just barely made it across the finish line. And so next time we're going to talk about what happens from here and where we go. We are headed now into the discovery phase of this lawsuit, and that is all private between the parties. We're not going to see anything related to discovery unless and until one of the parties, either the plaintiffs or the defendants, are seeking a motion to compel the discovery of certain things that they've requested. And so we'll check back in on that to see at some point whether the court makes a ruling on that. If so, we'll bring that to you. But as it stands here, next time we're going to talk about what happens next. And if you're involved in a labor and employment lawsuit, you now have a full understanding of the first round, the very first phase of what was going to happen in that lawsuit, how the judge is going to ultimately look at the law, make a determination about what should stand, and then we're off to the races with discovery. Discovery is a whole thing and a whole phase in and of itself, and we'll look at that next time. Thanks for joining us today on Pop Your Biz. For more information about my law firm, Business Law Group, check out our website at www.lawgroup.biz. You can also find us on all the major platforms, including Insta and Facebook, as well as LinkedIn. As always, if you liked this content, I really appreciate your positive reviews, comments, and sharing this show with others.